The first case to come before the court is State of Ohio v. Anthony Mignano. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know and I'll be keeping track of the time and try to alert you when you're growing near your time. The arguments are being recorded, so please come behind the podium, keep your voices up, and remain there. Please don't use the names of children or minors or victims during your argument. You can refer to those folks by initials or terms like the child. And we have read your briefs. We're ready to proceed, and I would just ask, appellant, would you like to reserve time for rebuttal?
Yes, I will, Your Honor.
Okay, and how much would you like?
5 minutes, please.
5 minutes, okay. And you may begin when you are ready.
Good morning, Your Honors. To please the court. My name is Paul Gray, and I represent the appellant in this case. I was not the trial counsel, so I will do my best to elicit the facts as I understand them through the transcripts. Your Honor, I wanted to let the court know that there's one small error, but it's a huge error in this case. My client asserts that his due process rights were violated when a care center interview of the child was permitted to be used as evidence against my client without the ability for him to cross-examine that person. I want to say from the start that we're all sorrowed that this child ended up dying. I don't know the circumstances surrounding that, but this child died sometime after the care center interview. Your Honor, to start off with, my client was charged with 6 counts of first-degree rape of a child under 13, gross sexual imposition, and contributing. He was given the opportunity to file a suppression in this case based on the fact that the state was going to use the care center interview, and the state did not respond, but they filed their own motion to eliminate. The court held a hearing and concluded that the evidence deduced by the care center of the child was non-testimonial, and that there were the test under Arnold had been met, that they could allow that testimony because it was under Rule 803. 4 is for medical diagnosis and treatment. And we contend that the court did have a very significant mistake in this analysis. The court concluded that there was no pending legal action. And I must say, I don't know how the court missed this, because this all came about due to a juvenile court visitation issue that had been conducted between the maternal grandmother and the father in this case.
Does that really matter, though, because in Crawford, it's not about the evidentiary, but whether there's an ongoing emergency, correct? So ongoing emergency clearly isn't, or is there an argument that there is an ongoing emergency during the time of this interview?
There was not an ongoing emergency. It had been stale, I'll say. That the allegations had been months prior to the actual care center interview. But my purpose in the end is in looking at what is the motivation. The child may have been motivated to lie, or at least influenced, let me put it this way. And the influence comes from, as we can know from our practices and case studies, that domestic relations, when it comes to using a child for whatever the purposes are, for gaining custody or visitation, or whatever that issue may be, is one of the biggest things that adults put children in the middle of. And for the court not to recognize that this information came forward as somebody who was eliciting it to better their position during the visitation hearing, that they use that information thereafter to get police involved. And for the courts to rule in their analysis that there was no pending action, that there was no pending legal action, a lack of motive to lie during a pending legal action. And that is a quote from the court. And the fact that it was not considered, I think, is detrimental and severely prejudicial to my client, because that is the very initial part of this whole investigation. Moving from that, the police are conducting their investigation. Let's call it what it is. And anybody from the start of Detective Brown's investigation and then not calling it an investigation is just trying to look at us like we're silly. Because detectives don't start talking to parents. They don't start talking to defendants once and then twice if there's not an investigation. They don't make referrals to parents to go to the care center so that the social worker on duty, who's a forensic expert also, can do their analysis and get evidence for the detective. The detective says, I go to these things because I know I can get evidence of who did this. And if you're going to say you're not investigating, but you do all the things that an investigator does, then you're not being honest with the tribunal. You're not being honest with your motives. And if we're looking at a reasonable person standard for how this is set up and why it's set up, then you can only conclude it's for investigative purposes, police investigations. I wanted to also say that we get great insight from Miss Boyd, Miss Dudley at the time, who is the master's in social worker doing the care center interview with the child. She goes to great lengths, and I think she slips a couple times. And I'll refer to the court that she indicates that she talks to Detective Brown for an overview of the case before the interview, but she doesn't keep any notes. So that when you question her, all she can say is that she understands that this child was abused by a friend of the father's while in the house. But she doesn't remember any details of what has been given to her. I find that a credibility issue. Then she'll say that the reason that the police are there is to keep the child safe. If you're not doing an investigation where you have not concluded anything, why would you say that you're keeping the child safe? That's why you have police there. When we know that hospitals have their own security. So I think this is a pretext to try to deny that this was a police investigation. Finally, she says twice, she uses the word case. This is Miss Dudley, Miss Boyd. She says she speaks to law enforcement prior to her speaking to the child to talk about the case. Your Honors, we're not talking about a case study for medication. We're not talking about new and improved medical procedures that this would be a case study for. The word case applies to one thing and one thing only, and that is the investigation of this defendant in needing corroboration through Emmy's or the child's interview. She also goes on to say later that she discussed the case with the nurse thereafter. The case, once again, circling back to the pretext that this is for medical diagnosis treatment. The case is about the investigation. The case is about their building and trying to look at evidence for the case that they're going to bring in a criminal matter. Finally, Your Honor, I would like to say that Ms. Brown, in her own testimony, supports the fact this is the case by saying that they usually interviews to identify a person who's engaged in the conduct. I'm sorry, this is the detective. That they use these interviews to identify a person who engaged in the conduct, and they consider that evidence. So, Your Honor, for all these reasons, this was a police investigation where it was testimonial nature when they were trying to get this child to elicit the substance of what happened to her. And I would add that there was no evidence that this child was ever treated thereafter, none whatsoever. The only thing that happened is that they made a referral to CSB, which Summit County Children's Services Board which we all know is another investigative arm to protect the child. And they do that by getting the courts involved, getting court orders, and having interviews with responding parents and children. And that leads also to support of a police investigation. Thank you, I reserve the rest of my time.
Thank you. You will have your full 5 minutes on rebuttal.
Good morning, judges. May it please the court. My name is Rick Raley. I'm appearing on behalf of the state of Ohio, the appellee in this matter, and Summit County Prosecutor Elliot Kolkovich. I do want to just briefly respond to our arguments. I do think this is pretty fully briefed, and I think that there's well-settled law that applies to the arguments that we just heard. The evidence here is that the social worker conducted a diagnostic interview for the purposes of medical treatment of this child. And in fact, we just heard, as Mr. Grant outlined, after receiving this information, she talked to a nurse who could then provide treatment. And that was followed through. Now, there were no suggestive questions during her argument. She described the diagnostic technique.
I'm gonna stop you right there because you're talking about case law, I think, about the rules of evidence. Not in the context of Crawford, where there's an additional element of this testimonial versus non-testimonial and ongoing emergency.
I would disagree with that. State versus Arnold was about the constitutional issue of the confrontation clause. State versus Deaver is also about the identity of the perpetrator, something that can be elicited without violating that. So no, my cases I'm talking about right now, and the thoughts are about the confrontation clause, which are the purposes, statements made for the purpose of medical diagnosis are not testimonial. That is what courts have found time and time again. So the minute that we find that this was for medical diagnosis, the confrontation clause analysis is done, in my
And
opinion.
do we have specific cases too that involve a social worker? Because my understanding is social workers can't make diagnoses.
So there are questions about social workers indeed, but I can tell you that the State versus Arnold case is about statements made at child advocacy centers. Social workers, there are many cases about the ability of them to hear the information and then give them to the nurses. Basically, the idea is they have a better skill set to understand the child and explain it to the nurse before the nurse does the treatment. So it is part of the treatment, although they are not a medical professional, they're a social work professional. This discussion about a juvenile court case, I just checked the brief again that was filed. I don't see any argument about a juvenile court case and whether that created a motive to lie. So I'd say that's something that if this court is concerned about, there should be supplemental briefing on at bare minimum. I think it would be waived at this point under the rules of appellate procedure. I will say that from what I can, accepting what was just described to us as true, when we talk about a juvenile court case, if there was some sort of custody battle involving this child picking someone to get away from, that is when there'd be a motive to lie. That doesn't exist in this case. I'd also say the Care Center interview, which is included in the record, shows the discussion beginning about the need to tell the truth. There's a discussion about, only the truth is being spoken in here, and that's also going to the reliability. And ultimately, the reliability of the statement is backed up by the fact that the defendant himself admits sexual conduct with his child. So I think that's pretty good reliability evidence. So I do think it's just important, all the evidence in this case from the questionnaires that she uses a diagnostic process, not forensic, that I don't think that there's significance to the use of the word case in her discussion of in her testimony about it. I know social workers typically refer to what they have handled as cases. I know medical doctors refer to it as cases. There should not be significance if this court attaches to that to say this is a pretextual discussion for the purpose of the police investigation. And with that, I would just go, the Deaver case from the Supreme Court says you cannot be overly strict about this child's discussion, what their motivational purposes are, but all of the factors this court has previously recognized as indicators for medical diagnosis support a finding of medical diagnosis, just as a trial court. So if there are no further questions, I would just ask you to affirm.
Hearing none, thank you, counsel.
Your Honors, I do want to correct myself. I did say juvenile court, it was domestic relations, excuse me, and it was for visitation issue, not a custody issue. But therein lies the same kind of tug of wars that can happen in both situations that I'm referring to, whether it's a juvenile court or domestic relations, custody versus visitation, those type of things are a motive, and it is a pending legal matter. The other thing I'll say, Your Honor, is the prosecutor brought that corroboration by the fact that the offendant confessed or gave a statement against himself in this matter, which led to him losing the suppression hearing and then pleading no contest. The state is trying to say in their brief that there wasn't a police investigation. I don't know how you can have it both ways, Your Honor. If there's either a police investigation or there's not, and all the indications here is that there was a police investigation. And as I described earlier, but if you add talking to the defendant and trying to get their version, and you get a final corroboration, as the prosecutor says, then you're doing a forensic evaluation at the care center to get that corroboration that the child was actually injured. You may have somebody who wants to confess to something that didn't happen. But you're gonna have to do some more work, and that more work was referring them by the police to the care center, to the social worker, to fact check what they think they know. So this was a non-emergency investigation for the purposes of testimonial recordings at the care center. Thank you.
Thank you, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it's released, and the opinions are also posted on the Ohio Supreme Court website. Thank you both again.
Thank you, Judge.